Transfer of deed. A deed transfer need not satisfy the statute of frauds, but the grantor must have the present intent to transfer. It must be in writing, signed by the grantor, name the grantee, contain a reasonable description of the property, and be witnessed by 2 attesting witnesses. Recording a deed is a presumption of the intent to transfer. Vested remainder. A vested remainder is a future interest and exists when there are no conditions precedent to the grantee receiving the property. Tenancy by the entirety. A tenancy by the entirety is a joint tenancy with a right of survivorship between a married couple and requires 5 unities of time, title, possession, interest, and person. Upon death of one tenant, their interest goes to the other tenant. One tenant may not alienate or encumber the property without consent of the other. The tenancy terminates upon divorce, death, or consent of both parties. A tenancy by the entirety is presumed in Florida when property is transferred in the name of both spouses, or one spouse transfers title to the property to himself and his spouse. No strawman is required. A joint bank account in the name of both husband and wife is also presumed to be owned as a tenancy by the entirety. As stated, a divorce terminates a tenancy by the entirety and creates a tenancy in common but not separation. Mortgage. Florida presumes that a person who receives property takes subject to a mortgage on the property if the deed is silent. The property will remain subject to foreclosure, but the transferee will not be liable for the mortgage. The mortgager remains liable to the lender. Foreclosure. A mortgagee may foreclose on property when the underlying obligation to which it relates is in default, typically due to a failure to make payments. To foreclose on property, Florida requires the plaintiff show standing. He must show that he is the owner of the note and obtained ownership prior to the foreclosure action. Ownership may be proven through an unbroken chain of self-authenticating assignments. He must also name the parties to the foreclosure action. Priority. Foreclosure of a senior interest at a judicial sale eliminates all junior interests on the property so long as notice is given to the junior interest. Whether an interest is junior or senior is determined by the first in time first in right rule. Deficiency. Florida allows for deficiency judgments. If the foreclosure of the mortgaged property is not enough to cover the amount of the debt that it relates to, the mortgagee may recover the deficiency from the mortgager. Purchase money mortgage. A purchase money mortgage exists when the mortgagee gave the loan that allowed the mortgager to purchase the property. A purchase money mortgage has a superior interest over other creditor interests. Deed recorded. A deed need not be recorded to be valid, but recording sets up a priority between competing claims to a property. Florida is a pure notice jurisdiction and provides that a subsequent purchaser for value has priority if he takes without notice of a prior unrecorded interest. Notice can be actual, constructive if it is recorded, or inquiry. Florida requires a purchaser to conduct a good faith reasonable investigation of the property to determine if there are any other interests. Express easement. An express easement is created when parties agree to allow a dominant estate a specific use on a servient estate. A person using an express easement beyond the stated use is liable for surcharge for the value of the overuse. Foreclosure. A mortgage may be foreclosed by the mortgagee if the mortgager fails to pay their obligations on the note secured by the mortgage. Mortgage. A mortgage is a property interest that attaches to the land until terminated. Florida is a notice jurisdiction state. A property interest, like a mortgage, is only valid against subsequent purchasers for value if they have notice or the prior interest is recorded. Eviction. The right to evict a tenant belongs to the estate owner. Unless otherwise agreed, only material breaches of a lease will permit eviction. Minor breaches only permit damages as a breach of contract. Absent a breach or other lease terms, a tenant cannot be evicted. Termination of easement. An express easement is generally irrevocable absent all parties' agreement. However, overusing the easement may give rise to a surcharge action. See above for discussion. Purchase money mortgage. A PMM exists when the money that is loaned is the money that is actually used to purchase the property for which the loan was obtained. Mortgage transfer. Generally, when a mortgager transfers his interest to a new buyer before the mortgage is paid off, the buyer takes the property subject to the loan. While the lender may still foreclose on the property, the buyers will not be personally liable and do not need to cover any deficiencies. However, sometimes the buyers will agree with the seller to assume liability for the mortgage. Tenancy by the entirety. Tenancy by the entirety requires unity in time, title, interest, and possession. This means that the tenants must take an interest in the property at the same time. The land must be granted to the tenants in the same instrument, like the deed. Their interests have to be equal, such that, for example, one party does not have a life estate when the other party has a fee simple, and they must have the same right to possession, so that both tenants have a 50-50 interest in the property. In Florida, married couples are presumed to be tenants by the entirety unless otherwise specified. Tenancy severance. A lien holder only has an interest in that tenant's estate. Moreover, when a piece of property is granted to a married couple, and the deed says, and, both spouses must agree before transferring interest in the property. Effect of the foreclosure. When a lender forecloses on property, it must notify all junior security interests when it files suit. Generally, the foreclosure of a senior mortgage interest will extinguish not just the interest being foreclosed upon, but all other junior interests. Senior interests are still protected after a foreclosure. Valid deed. In order for a deed to be valid under Florida law, it must be attested by 2 witnesses, contain an accurate description of the land and properly delivered. In order for a deed to be properly delivered, physical delivery is not required. Delivery to a third party on behalf of the recipient is enough to constitute delivery under Florida law. Joint tenancy. In order to hold property as joint tenants with rights of survivorship, 4 unities must be present. 1. Time. 2. Title. 3. Interest. 4. Possession. This means that the parties taking interest in the property must take the interest at the same time, by the same title, with the same interest in the property, and have equal possession to the property. Additionally, specific language must be found in the deed in order to create a joint tenancy, such as with rights of survivorship. Without that specific language, Florida law assumes the creation of a tenancy in common. Severance of joint tenancy. A joint tenancy with rights of survivorship, JT, allows either party to encumber their interest in the land as they wish. This means that either party may take out a mortgage and use their interest in the land as collateral or may allow creditors to place a lien on the property. However, such an encumbrance does not alter the other party's interest in the JT so long as the JT is in a lien theory state. A lien theory state, like Florida, allows either party of a JT do to whatever it desires with their interest in the property without severing the JT. However, in title theory states, placing a mortgage or a lien on the property or conveying the interest to someone else automatically severs the JT and the JT becomes a tenancy in common. Statute of frauds. The sale and lease of land falls under the Statute of Frauds, SOF, and thus must be reduced to a signed writing in order to be enforceable. The signed writing must include the names and signatures of the parties to be charged, an adequate description of the land, and a sale price if it is determinable. Periodic tenancy. A periodic tenancy is created when parties agree to rent for a set period of time with payment at set intervals. In order to terminate a periodic tenancy, Florida has very specific rules. If the tenancy is year to year, the notice must be given 6 months in advance. Quarter to quarter equals 3 months. Month to month equals 1 month. Week to week equals 1 week. Actual waste. As a life estate holder with interests that will follow your interest, you have a duty to not commit waste on the property. There are 3 different types of waste: 1. Actual, 2. Permissive, 3. Ameliorative. Actual waste is exploiting the natural resources that are already on the land. The owner of the property is not permitted to overuse the recourses on the land so as to drain the land of its natural resources unless the land is only good for that reason, the landowner was given permission to do so, or it was previously used for that reason. However, if it was previously used for that reason, the current landowner is restricted to only using what is already there under the open mines doctrine. This means that the landowner cannot open new mines for excavation but must work with what is already pre-existing. Permissive waste. Permissive waste refers to keeping the land in good condition. The landowner has a duty to maintain the land in a good condition. This just means any ordinary wear and tear on the premises, and not allow the land to go into disrepair. This also means paying taxes on the land. Ameliorative waste. Finally, ameliorative waste refers to waste that improves the value of the land. The landowner must not make substantial changes to the land that improves the value of the land. Eviction. An eviction can occur when a tenant violates the rules of the leasehold, such as not paying rent or committing waste. Waste can be either 1. Actual, 2. Permissive or 3. Ameliorative as described above. A tenant can also be evicted when a tenant is considered a holdover of the lease. A holdover occurs when a tenant stays beyond their rental period, in which case the landlord may charge the tenant double rent. Real estate contract. Alternatively, in a real estate 7 contract, the statute of frauds may be satisfied by showing 2 of the following 3 facts: 1. Payment of purchase price, 2. Physical possession of the land, and 3. Improvements to the land. Equitable conversion. When parties enter into a contract to buy property, the doctrine of equitable conversion provides that the buyer is the owner of the property and has the risk of loss as of the signing the contract. Tenancy by the entirety. When property is conveyed to a husband and wife during their marriage, it is presumed to be a tenancy by the entirety. This quitclaim deed was proper because Florida has eliminated the need to have a strawman in order to have a tenancy by the entirety. Title severance. Florida is a lien state, meaning that a mortgage acts as a lien on the property. The mortgagee, in this case seller, does not have title to the property, just a lien. Easement by necessity. An easement by necessity arises where one property is divided and that creates a situation where there is no other way to access a public road. An easement by necessity can terminate if that necessity is no longer there, such as a new road being built. Easement by adverse possession. In order for this easement to arise, there must have been access that was hostile or adverse, continuous, open and obvious, and for the statutory period. In Florida, that period is 7 years. Adverse possession. In order to prevail for a claim of adverse possession, the adverse claimant must prove that her use was open and notorious, hostile and under a claim of right, continuous for the statutory period, and exclusive under the common law. The period of time for common law is 20 years. An adverse claimant may also claim adverse possession pursuant to statute under color of title or without color of title. To prove under color of title, the adverse claimant must record the deed with the county clerk, which purports to vest title in the adverse claimant. To prevail on a claim without color of title, the adverse claimant must make a return with the tax assessor and pay the taxes on the property claimed. Both under color of title and without color of title require the claimant to be in possession for 7 years. Easement by necessity. In order to prove an easement by necessity, the owner will have to prove that she has no other access to a public road and must cross the northern property. The owner may sue the northern owner and he may be entitled to compensation. Once the compensation is paid, the easement is established. Even if she had an easement by necessity, the easement ends once the necessity ends. Under common law, an easement by necessity may exist over one property if the land was previously in common ownership and subdivided. If the subdivision leaves one property landlocked, the other will have an easement for ingress and egress. Easement by prescription. Owner must prove that her use of the road was open and notorious and continuous for 20 years in order to establish an easement by prescription. She must also prove it was hostile and adverse to the northern owner's interest. Tenancy by the entirety. Generally, a testamentary gift or inheritance by one spouse during a marriage is considered non-marital and held only by that spouse. However, in Florida, property that is acquired during a marriage in the name of both spouses is presumed to be held in tenancy by the entirety, TBE. TBE is a form of joint ownership that is similar to joint tenancy in that it includes the right of survivorship and requires the unity of 1. Title, 2. Interest, 3. Time, 4. Instrument. Additionally, property held in TBE is exempt from the execution and forced sale of creditors of only one spouse. The TBE ownership is considered that of a marriage and can only be severed by death, divorce, consent of both parties to the marriage to sell or mortgage, or execution by a joint creditor. Title severance. Because Florida is a lien theory state, the lien will not sever the JT and the creditor must execute and sue for partition to sever the JT. Real estate contract. Under FL law and the statute of frauds requires a contract for real property to be in writing signed by the parties, and under FL law signing of a deed requires 2 witnesses. The contract should include a description of the parties, the price, and any conditions agreed on. Additionally, a contract for real property in FL can have conditions unique to each seller and buyer, such as is clause, deposit amounts, or liquidated damages. Non-disclosure. Under FL law, a seller of new or used residential property has a duty to disclose known material latent defects of the property that are known to the seller and not known or reasonably attainable by buyer. Material defects are defined as defects that if known would cause a reasonable buyer to have second thoughts about purchasing the property. However, buyers are assumed to take precautions when purchasing property such as ordinary inspections. Parties can have notice of defects in 3 ways: constructive, where party discovers defects; inquiry, where some act puts them on notice that they should investigate further; or actual, where they were told. Under FL law, sellers of commercial property are not held to the same standard as residents and are not required to disclose defects. Parties are not living in them and therefore buyers have a greater duty to inspect. Damages, real estate. Expectational damages, designed to put the person in a position if the K had been performed, usually market price versus contract price. Reliance damages, damages that are designed to give buyer back money they spend in reliance of contract, or restitution damages, which are used by the court to prevent unjust enrichment. Equitable conversion. Equitable conversion applies where there is a contract for the sale of real estate. Equitable title is said to pass to the purchaser after the contract is signed, with legal title remaining with the seller. Recording deed. Florida is a pure notice jurisdiction which protects a bona fide purchaser, BFP. A purchaser is bona fide if they subsequently pay value for the land and have no notice of anyone's prior interest in the land. Therefore, the time and order of the recording of the deed is not critical to the validity of the deed. However, the recording of a deed is to give notice to the whole world of your interest in the property, record notice. Therefore, every purchaser should record their deed in order to prevent his interest in the property from being unenforceable against a subsequent BFP. A deed becomes enforceable once it is executed and delivered to the grantee. Homestead. The Florida Constitution provides homestead protection for qualified property against the forced sale by creditors. A property qualifies as a homestead if it is owned by a person, they are domiciled there, and it meets the acreage requirements. If the property is located within a municipality, it protects extends to 1/2 acre contiguous land and its improvements. If the property is located outside the municipality, it protects 160 acres of contiguous land and its improvements. If the property has homestead protection, the Constitution restrains the devise of the property if there is a surviving spouse or minor children. If there is a surviving spouse and no minor children, then the decedent may convey to the surviving spouse outright. If there is a surviving spouse and surviving minor children, then the decedent may not devise the property. If the decedent is not survived by a surviving spouse or minor children, he may dispose of the property how he pleases. If there is an improper devise, the property passes as it would an intestacy. Therefore, if there is a surviving spouse and one or more lineal descendants, then the surviving spouse will get a life estate and the lineal descendants will receive a vested remainder, per stirpes. If property is titled to a husband and wife, Florida presumes a tenancy by the entirety. If there is a tenancy by the entirety, there is no homestead protection. If husband and wife are married and they have either a homestead or tenancy by the entirety, both spouses have to join in the conveyance or mortgage of the property. Breach of covenants of title regarding the lien on the property. When parties enter into a contract for the sale of land, the seller has a duty to deliver marketable title. Marketable title does not mean perfect title, it is just title that a reasonable person would accept and the property can have minor encumbrances. Buyer and seller stipulated in their contract that the land would be sold as is, but seller would deliver marketable title. Marketable title is required to be delivered at the time of closing, and it means that the property is not encumbered by anything that was not previously disclosed. If there is a mortgage on the property and the proceeds from the sale will be used to pay the mortgage, marketable title can still be delivered. However, once the parties close, any covenants in the original contract merge with the deed and the buyer is limited to recover under covenants of title. General warranty deed. A general warranty deed contains 6 covenants of title. 1. Covenant of season, which says that the owner actually owns the property he is seeking to convey. 2. Covenant of right to convey, which means that the owner has the right to convey the property he claims to own. 3. Covenant against encumbrances, which means that the seller guarantees that there are no encumbrances on the property that were not previously disclosed. 4. Covenant of quiet enjoyment, which means that the seller will not be ousted from the property by someone claiming paramount title. 5. Covenant of warranty, which means that the seller will defend from any suits brought by someone claiming paramount title. And 6. Covenant of further assurances, which means if the seller did not convey valid title, he will do whatever is necessary to do so. Special warranty deed. However, under a special warranty deed, seller only covenants that he or she did not convey the land to someone else and that he or she did not encumber the land during ownership. The facts state that seller delivered a special warranty deed. Recording statute. Additionally, Florida is a pure notice jurisdiction. Notice can be by actual notice where the buyer knows of any claims to title, constructive notice where the buyer is on notice if the instrument is recorded, or inquiry notice where a seller has a duty to inquire into the land. Notice. Florida statutes do not impose a duty on a buyer to inquire into the land, but case law requires that a buyer make a physical inspection of the land. Non-disclosure. In Florida, the seller of residential real estate has an affirmative duty to disclose all facts materially affecting the value of land that are known or should be known to the seller but are not readily discoverable to buyer upon a reasonable inspection. Something materially affects the value of land if a reasonable person would think twice about entering into the contract if the fact were known. Damages, real estate. If rescission is not an option, buyer may be able to recover damages for the difference in value of the home with the defect versus the amount he paid. Contract damages are measured by expectation interest and are meant to put the parties in the position they would have been in had the contract been performed as expected. At the very least, buyer may be able to recover damages to fix the sewer problem. Consequential damages are also available in contract if they were foreseeable at the time the contract was entered into. Intentional misrepresentation. Intentional misrepresentation requires 1. A false statement of material fact, 2. Scienter or knowledge of the falsity of the fact, 3. Intent to induce the other party to rely on the misrepresentation, 4. Justifiable reliance by the buyer, 5. Causation, and 6. Damages. Fraudulent misrepresentation. Fraud when there is 1. Active concealment of a latent defect in the property, 2. An affirmative lie, or 3. Silence when there is a duty to speak. Scienter, knowledge of the falsity, must be proved and there must be justifiable reliance, causation, and damages. Easement. An easement is the non-possessory interest involving the right to use the land of another. Easements can be created expressly or impliedly. Easements can be affirmative if they allow you to do something with the land or negative if they restrict the owner's use of his land. Easements can be appurtenant, which means that there is a dominant tenement that is benefited from use of the easement. Affirmative easements run with the land. An in-gross easement is personal in nature and does not involve a dominant parcel of land. Real estate contract. The statute of frauds requires that contracts for land be in writing signed by the party being charged, and Florida requires the signature of 2 witnesses when conveying real property. However, where the requirement for a signed writing has been satisfied, as it is here, extrinsic evidence explaining ambiguities can be introduced by either party. The parole evidence rule will not prevent its introduction. That rule is complicated with real property, however, because there is a requirement that land be identified in the signed writing for a conveyance to be valid. Where there is an attempt made to identify the land, and extrinsic evidence is needed to clear up an ambiguity, it is unclear whether the conveyance is valid. Recording. Florida has a notice type recording statute, which says that a deed will not be good against a subsequent purchaser for value, or creditor, without notice if not properly recorded. Adverse possession. In Florida, that statutory period is 7 years. Also in Florida, the adverse possessor must notify the county property appraiser of his possession and pay all taxes thereon. Recording statute. Florida has a pure notice recording statute. Any subsequent purchaser for value without notice shall have superior rights in the property conveyed over previous purchasers who did not record prior to the conveyance to the subsequent purchaser. If a purchaser is found to be a bona fide purchaser, BFP, for value without notice, actual, constructive/record, or inquiry, that BFP has superior title. Foreclosure action. If the home is found to be homestead, as described above, any property up to 1/2 acre within a municipality and 160 contiguous acres outside a municipality, that is the primary residence of the owners, it is protected by the Florida Constitution against void mortgages as well. Generally, a mortgage on homestead property is enforceable against the property because it falls into one of the 3 exceptional kinds of creditors that can reach homestead property: mortgagees, those holding mechanics liens, and property tax lien holders. Mortgage. A mortgage on a homestead property of 2 spouses must be consented to by both spouses. If it is not, it is void. Any conveyances of title to homestead property must be joined by and consented to by each spouse of the property, or it is void. A mortgage is a transfer of interest in real property, even under Florida's lien theory jurisdiction, because while it does not convey actual title, it does convey a lien on the property, which is an interest in the property. Conveyance. In Florida, attestation of 2 witnesses is also required. The facts state that the deed conformed to all requirements of a valid deed, so we can assume this part is met. Notice statute. At common law, such multiple conveyances were settled by a first in time, first in right application. However, Florida is what is considered a notice jurisdiction. This means that regardless of who is first in time, we will protect a subsequent good faith purchaser for value, so long as they took without notice. In order to take without notice, a buyer must have neither actual, inquiry, or constructive notice. Actual notice means that the buyer either has been told, has seen, or has any other personal knowledge of a prior conveyance. Inquiry notice is notice that would be imputed to the buyer had he made a reasonable inquiry into the situation, either by looking up unrecorded transactions or questioning a person in possession of the land. Lastly, constructive notice is imparted to a purchaser if the prior conveyance has been properly recorded. In Florida, whereas proper recording is constructive notice, a lack of recording creates a presumption of no notice. When this happens, the burden is on the prior purchaser to show actual notice. Equitable conversion. Under the doctrine or equitable conversion, once the K for the sale of property was signed, or proved by a substitute for signing, equitable title to the property vested in buyer, even though seller still had actual title, and both parties would be able to enforce specific performance of the K in court. Specific performance is a valid remedy because land is involved, and damages alone would not provide the parties the benefit of their bargain. Notice recording statute. FL operates as a notice jurisdiction for the sale of property. In FL, buyers of real property are subject to actual, constructive, and inquiry notice. A buyer has actual notice of a prior conveyance if he or she actually knows that there was a prior conveyance, and a buyer has constructive notice when the prior conveyance has been recorded in compliance with the recording statute. Neither was the case here because the sale to buyer was not recorded, and the facts do not indicate that investor had actual knowledge of the conveyance to buyer. However, in FL a buyer is also subject to inquiry notice, via case law, which puts the duty on the buyer to take a physical inquiry of the property to determine if someone else is in possession, and if they are to inquire as to their ownership rights. Covenant of warranty. These covenants are season, right to convey, covenant against encumbrances, quite, enjoyment, warranty, and further assurances. In a land sale contract, the damages that investor would receive are the difference between the market price of the property and the contract price of the property. Real estate contract. A contract for the sale of land or for an option to purchase land must be a writing, describing the property and the price to be paid, and it must be subscribed by 2 witnesses and recorded. An option to purchase property should be recorded like a deed and have consideration for the option to be left open. Notice statute. Florida is a pure notice state. This means that a buyer who is a good faith purchaser takes good title if they purchase without notice of anyone else having an interest in the property. Florida has a rebuttable presumption that a person doesn't have notice when they buy land. Record notice is when someone records their interest in the property, and it gives notice to the whole world that they have interest in the property. When people buy property, they are presumed by the law to be on all forms of notice, including actual, inquiry, and record notice. Covenant of season. Which warrants that the title is marketable and good and that there is nothing of record that affects the title. Covenant of warranty and defend. Which promises that owner will show up to defend his ownership in the property should any lawsuits arise. Covenant to convey. Which promises that owner had the right to convey the property. Covenant of quiet enjoyment. Which promises that no one has a lawsuit against the property and buyer can own it in peace without worrying that he will be thrown off it. Covenant of future assurances. Owner promises that he will execute all paperwork or do anything in the future he needs to do regarding the property. Covenant against encumbrances, which promises that owner didn't have encumbrances or liens on the land other than what owner has told buyer about. Easement creation. An easement can be expressly or impliedly acquired. It may be given in a deed, obtained by necessity of use, or acquired through adverse possession, also called a prescriptive easement. A landlocked property is always granted an easement off the land by necessity, but the owner of the servient estate, the one being burdened, usually will be able to choose a reasonable location for the path across his property. Prescriptive easement. Prescriptive easement. The period for adverse possession of an easement in Florida is 20 years, while it is 7 for other property. For a prescriptive easement, the elements include adverse, notorious, continuous, hostile, open, and exclusive possession. Sovereign immunity. The municipality retains a sovereign immunity similar to the state in that its discretionary functions are protected, deciding whether or not to erect a bridge for the public good, while its ministerial or operational activities generally are not. Failure to replace rotten planks on the bridge, exposing citizens to harm. In Florida, sovereign immunity has been waived to the extent of $100,000 per person and $200,000 per incident. If the municipality has taken out liability insurance, it will be responsible up to the amount of coverage, an amount up to which the city has been said to have waived its immunity. Taking. When the government institutes a regulation that has the effect of a total deprivation of the value of a citizen's property, then the citizen has a claim to the reasonable fair market value of his property, which is seen as having been taken and necessitating compensation under due process and the Constitution, both Florida and federal, Fifth Amendment right to life, liberty, and property applied to the states through the 14th Amendment and requiring fair notice and a hearing prior to the deprivation of these privileges.